Assalamualaikum and good day to everyone. We are from Group 3 and today we would like to present about the topic mistake under the law of contract. So in contract law, a mistake refers to a misunderstanding or incorrect belief held by one or both parties when entering into an agreement. A mistake can make a contract invalid or unenforceable depending on its nature. Mistakes are mainly divided into mistake of fact and mistake of law. To begin with, under Section 21 of the Contract Act 1950 stated, when both parties to a contract are mistaken about a fact that is essential to the agreement, then the contract is considered void. This means the agreement is not legally binding because there is no true free consent between the parties. The law will treat the contract as if it never existed to protect both parties from unfair situation arising from such mistake. For Section 21 to apply, there are three important requirements. First, the mistake must be made by both parties, meaning it has to be a mutual mistake. Second, the mistake must relate to a fact, not something related to law, opinion, or future expectation. Third, the fact that is mistaken must be essential or fundamental to the contract. For example, if both parties agree to buy and sell a horse, but neither knows that the horse is already dead, this is a mutual mistake about an essential fact, and the contract will be void. Next, it's also important for us to understand the difference between a mistake of fact and a mistake of law. So earlier, we already talked about what a mistake of fact is. Now, let's take a look at what a mistake of law means. So a mistake of law happens when someone enters into a contract based on a misunderstanding or ignorance of the law. So according to Section 22 of the Contracts Act 1950, this type of mistake does not affect the validity of the contract. In simple terms, the contract remains valid even if one or both parties are wrong about what the law actually says. This is different from a mistake of fact, which we discussed earlier under Section 21. If both parties are mistaken about an essential fact of the agreement, the contract may be considered void. And it's also important to note that if someone make a wrong assumption about the value or quality of an item, for example, believing that a product is worth more than it actually is, this is not considered a mistake of fact. It's just an opinion and it does not make the contract void. So to help us understand how the law is applied in your situation, let's look at the case example, which is the case of Ho Weng On and Binde. In this case, the defendant sold a piece of property to the plaintiff, but the truth is he had already sold the same property to someone else a year earlier. Only the defendant knew about this, while the plaintiff had no idea. Since the mistake was only on one side, the plaintiff was mistaken, but the defendant knew the real situation. This is not a mutual mistake under Section 21. Therefore, the court decided that the contract was still valid and the plaintiff was awarded damage for breach of contract.
Assalamualaikum. So I will be presenting on the illustration to Section 21 of the Contract Acts and giving an overview of the four main types of mistakes that can be made by both parties in a contract. So Section 21 states that a contract is void if both parties are mistaken about a fact that is essential to the agreement. So the Act provided three key illustrations to clarify this. So illustration A agrees to sell B a specific cargo of goods supposed to be on its way from England to Kelang. So it turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. So neither party was aware of the facts. The agreement is void, meaning that both A and B believe that cargo exists and is on the way, but in fact it was destroyed before they met the contract. So since the cargo no longer existed, no valid contract could be formed. So for illustration B, A agrees to buy B a certain horse, and it turns out that the horse was dead at the time of the bargain. Neither party was aware of the fact, so the agreement is void. So the explanation: the contract is based on the assumption that the horse is alive. Since the horse had died before the agreement, there was no existing subject matter, making the agreement is void. So for the illustration C, A, being entitled to an estate for the life of B, agrees to sell it to C. B was dead at the time of the agreement, but both parties were ignorant of the facts. So the agreement is void, meaning that the estate is only valid during B's lifetime. So since B was already dead, A had nothing to sell, so, and thus the contract was void due to the non-existence of the estate interest. So there are four types of mistakes made by both parties. First, mistake as to the existence of the subject matter. Second, mistake as to the identity of the subject matter. Next, mistake as to the quality of the subject matter. And lastly, mistake as to the possibility of performance.
In contract law, a mistake as to the existence of the subject matter occurs when both parties enter into an agreement believing that the subject matter exists, but in reality, it no longer exists or never existed during the agreement. When this happened, the law considered that there was no true agreement because there is nothing for the parties to contract over. This principle applies when the subject matter of the contract is presumed to exist, but in fact it does not. The key point is that non-existence of the subject matter makes performance impossible and remove the basis of the contract. In such cases, contract is considered nullified as the parties were not truly agreeing to anything real. When a mistake of the subject matters occurs, firstly, the contract is void ab initio, which is void from the beginning. Second, no rights or obligation arise. And lastly, any benefits received must be returned. In the case of Galloway and Galloway, a man and woman entered into a separation agreement assuming they were legally married. Later, it was discovered that they were never legally married in the first place. Since the marriage, the subject matter of the agreement did not exist, the court held that the separation was void. So, a contract is void when the assumed subject matter, which is in this case the marriage, does not exist. Both parties were mistaken about the fundamental fact, making the agreement a nullity. This case involves a common mistake of fact about the existence of the subject matter. The law views this as a lack of free consent. Although both parties agrees on the term, they do not agree on the actual state of reality, which defeat the purpose of the agreement.
Mistake to identity happens when both parties are referring to different things. For example, Mr. A offers to sell his Perdua Maibi, but Mr. B thinks it's the Perdua Asia. Since both parties have different understanding, there is no true agreement and therefore no contract is formed. For example, in the case of Flag and Williams, where confusion over two shipping contracts led to no valid agreement. In this case, both parties were discussing two different shipping contracts, one for Shell and one for Copra. Because both parties misunderstood each other, the court decided there was no real agreement, so no valid contract was formed. Next, mistake as to quality happens when both parties agrees on the item but have different understanding of its feature or condition. For instance, if both believe the strawberries were old but they turn out to be new strawberries, this affects the value or purpose but not the identity. Here, the contract remains valid because such mistake is not recognized under Section 21 of the Contract Act. Under Section 21 of the Contract Act says that a contract is void if both parties are mistaken about a fact that is essential to the agreement. This is called a mutual mistake. For the section to apply, the mistake must be about a key fact, not just price, quality or opinion. If it's only a mistake about value or worth, the contract is still valid, so Section 21 doesn't apply in that case.
Next, I'll be talking about mistake as to the possibility of performing an agreement. Under the contract law, if the subject matter of a contract does not exist, the agreement is void. For example, if you agree to sell a horse that had already died without knowing it's impossible to deliver, and so the agreement becomes void. This rule also applies when the performance of the contract is physically impossible due to a common mistake made by both parties. If they both believe something can be done, but in reality it cannot, the contract becomes void. Let's take a simple example. Abu gave access to Badrul to cultivate his 5-acre paddy field for 10 years. They agreed that Badrul would deliver 10 tons of rice every harvest. But Badrul could not meet that because 5 acres simply cannot produce that much rice. This is a mistake of fact essential to the agreement, and therefore, under the law, the agreement is void. This was also seen in the case of Sheikh Bros Ltd and Oceanal, where a license was given to deliver 50 tons of sisal fiber per month from land in Kenya, but the land could not yield that much. The Privy Council ruled it was a common mistake of fact, so the contract was void. In summary, if the both parties are mistaken about a key fact, making performance impossible, the contract has no legal effect.
Unilateral mistake is explained under Section 23 of the Contract Act 1950. This happened when only one party makes a mistake in a contract. Under the law, the contract is still valid. There are two common types in this mistake. The first one, a mistake as to the subject matter. For example, someone buys a painting thinking it's by a famous artist like Lan, but it's actually by someone unknown. Since only the buyer made the mistake, the contract remains valid. The second one, a mistake as to identity. Like if A thinks he's dealing with a rich person, but actually contract with a fraudster pretending to be that person. In the case of Ho Wing On and Bindu STN BHT, a developer mistakenly sold the same house to two buyers. The court held it was a unilateral mistake by the developer, so the contract was still valid. Lastly, for the case involve bona fide purchaser, the law protects them. That means the person gets a good title and cannot be forced to return the goods. There are two remedies under unilateral mistake. The first one, restitution. Under Section 66 of the Contract Act 1950, when a contract is discovered to be void, restitution applies, meaning any advantage received must be returned. The second one, rectification. Rectification is used when a written contract doesn't reflect the actual oral agreement due to a mutual mistake. Like in the case of Oh Hyam and Tam Kok, the both parties agreed orally to sell only rubber land in Gombak, but the written contract mistakenly included land in Setapak. So the court corrected the contract by removing the Setapak land.
That's all from us. Thank you.